I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are twisting the knob on the door of compilation 229 and walking straight into room 229 for a compilation that we're going to have 3 different judges in. Before I give you those judges' names, don't forget to like, comment, share, and subscribe. And also, commentary will be left in as usual from when these previously aired, and we will have chapters added for your convenience. Now, the 3 judges' courtrooms we will be in. First, we will be in the courtroom of Judge Brock Swartzle out of the state of Michigan. Second, we will be in the courtroom of Judge Joseph Lee out of the state of Kansas. And last but not least, we will be in the courtroom of Judge Sean Perkins, also out of the state of Michigan. As always, it is a pleasure to bring you another compilation. And listen, let's go ahead and jump in.
I believe you're entitled to 10 minutes of oral argument. If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Craft, the legal persona. I am not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for the summary judgment, please.
You asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has 2 jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on me?
We're acting under the state Constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits, and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kirnar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people just representing themselves. And that's what took place in this matter. In Article 1, Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. And Monell versus Department of Social Services, which is a New York State case. The Supreme Court case established that municipalities liability under the section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I deny any consent or any contract with the state or Title 4D agency to give away my biological and genetic material. That the case Monell is relevant because it underscores the importance to ensure that government agencies like the friend of the court on this context, these are for-profit agencies disguised as government agencies like the friend of the court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, was this a constitutional court? The asking for genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirements. I see that they're not here today, and that's some questions that are raised, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnosis Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers, 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test. And if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarms. The state of Michigan is also a business. And with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for just quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure. In Burns 322 BR 719, a creditor must provide proper documentation such as a promissory note contract to substantiate a debt or court claim. They did not. More documents I found. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Friend of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a corporation. I'm a living, breathing person, human being. With these being businesses, they have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458 of the Social Security Act, incentive payments to state. It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them for, it incentivizes them to collect more child support. The main argument I have here and for you guys is full disclosure. You know, it seems like they enter me in a contract without my consent, without full disclosure, and that's the problem here. You know, I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22. And it's basically it's evidence is they didn't provide any evidence of an injury or injured party. And
Mr. Kraft, you're out of time. We understand that you raise issues of disclosure,
yes,
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know, we have your brief. We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case, and then you'll get an opinion from us sometime within the next few weeks.
If
okay?
I may, one last thing.
You've got, if you can do it in 20 seconds.
I can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I would ask you to dismiss this without prejudice.
Well, guys, we've come to the end of another very interesting proceeding. And the reason why I say that is because I've never seen anybody use the sovereign citizen script in this manner, in a way where, you know, they're trying to use it to avoid taking a paternity test to possibly have to pay child support if that child is his. I've never seen that before, but we see the first thing he does is, he says he wants to check and see if this court is legitimate. But once again, something that we see sovereign citizens do that doesn't make sense is he challenged jurisdiction, but he was the one that put in to the court of appeals. So that just didn't really make sense. If you're challenging the jurisdiction of the court, or you don't believe the court has jurisdiction over you, then why would you try to turn to the court, for help in this matter, right? It just doesn't really make sense. And we hear him keep saying, I choose not to contract with these companies, they're corporations. He kept sharing the Dun and Bradstreet numbers. But it sounds like to me, I don't want to assume that he doesn't want to pay child support. I mean, I don't know what his relationship with the young lady is, but obviously he's using this sovereign citizen script to try to get out of taking this paternity test. It could be a number of reasons. It could be because he doesn't want to be with the girl, doesn't want the child, doesn't want to pay child support, doesn't believe the child is his. It could be a number of reasons. I'm not here to assume, but it definitely was very interesting to watch and see. If I get any updates on this case or what ended up happening, if they made him take the test or not, I'll let you guys know. But with that being said, guys, that's it from me. This is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. See you guys in the next proceeding. God bless.
State of Kansas versus Isaiah Curvin, 24 TR 17. Would counsel state their appearances, please?
I'm here, Your Honor.
May it please the court, the state appears by Jill Gillette counting it.
And you're Isaiah Curvin, correct?
Correct. Yes, I'm here.
Thank you. All right, Mr. Curvin, there was an earlier date where you failed to appear A warrant was issued. You were picked up on that. You posted bond. The court order was for you to appear at the sheriff's office, which you've done. We'll move on. Today was set for a pretrial. At an earlier hearing, you had pled not guilty, or plea of not guilty had been entered on your behalf. I have reviewed the file. There was a document entitled Notice of Special Appearance by Affidavit. Mr. Kervin, did you file that?
Yes, sir.
All right. I have reviewed that. Ms. Gillette, do you wish to make a comment on it before I rule?
I do not, Your Honor.
Very well. Mr. Kervin, is there any brief statement that you want to make in support of your motion?
Oh, well, I want to ask a couple of questions before we get on to anything.
You can start.
Okay. Yes, I want to know what I'm going to be tried, jurisdiction I'm going to be tried under. Is it
All
going
right.
to be civil or is it criminal?
I think we went through this before, and you're charged in the state of Kansas, and this is the Elk County District Court.
Okay.
So you are charged with operating a motor vehicle without a valid license. That is a Class B non-person misdemeanor, punishable up to 6 months in the county jail and a fine not to exceed $1,000.
Yes, I still don't understanding. I don't understand. Is that a criminal or is that a civil? Is that a criminal?
Well, Mr. Kervin, I've seen these motions before. I think you well understand where you're charged and what you're charged with. So let's not fool each other here or play games, please.
No, I'm not playing any games. This so I can properly defend myself because criminal and the civil, there are two different ways of doing things. In order to properly defend myself, all I have to know which one am I going to be tried against.
You are charged in a traffic matter that is treated as a criminal. You would have the right, all the same rights that I mentioned earlier when I went through the rights. You would have the right to a trial by jury or court if you make the timely and appropriate motion in writing for the jury. Otherwise, it would be a bench trial. The duty would be on the state to prove you guilty beyond a reasonable doubt.
Okay. And you said it would be a criminal matter, you said?
I mentioned that already, how it's treated. It's a traffic case.
Okay, that's what I was asking, just to verify. So if it's criminal, if it's under the criminal, then it has the court grants this under Article 6 to jurisdiction under the criminal matter.
Okay, Mr. Kervin, I have read through your motion. I disagree with your assertions of the law. Your motion is denied. We will set this matter for trial. Are you going to be representing yourself, or are you going to hire an attorney?
Well, before I go to trial, I have to know what's some questions I really have to have answered before I can enter anything, so I can properly defend myself.
I've answered the questions that are appropriate. Now, your motion and the things that you have in there, again, they're not accurate statements of law in regards to these type of proceedings. Your motion is denied. So we're going to set this matter for trial.
Okay.
I need to know if you are going to be represented yourself, or are you going to be hiring an attorney?
Can I ask what is the reason for my motion to be denied?
I've already ruled on it. It's not applicable law to this case. So, and your assertions of what the law is are inaccurate to a large degree. So
that's
I'm not going to go through line by line to do that.
No, I'm just trying to see to understand which ones you're referring to, so I can understand what was wrong, so I can know which one you're stating that's inaccurate, so I can have an understanding.
All right. So my question is, are you going to represent yourself, or are you going to hire an attorney?
Well, before we get to that, I have to know how to defend myself.
All right. We're going through this cycle here, and I'm not going to play the game.
No, I'm not. I'm talking.
Sir, be quiet.
Hmm.
You're here for a pretrial where you're not being responsive to my questions. If you want to have an attorney, you have the right to have an attorney. If you wish to be represented by counsel and if there's any risk to jail, typically there are times where there is a jail sentence that gets attached to this charge. You can apply to the court. If you meet the criteria, I'd appoint an attorney to represent you. Like I told the gentleman before you, that doesn't mean that you're going to be free. You also have a right to represent yourself. Those are the choices that you have. So you can hire an attorney, you can apply for one, or you can represent yourself. It's one of those three. Which one are you going to do?
Well, from my understanding, once jurisdiction is challenged, it's on to the plaintiff to prove the jurisdiction on the record.
That's at a trial. One of the issues that the state would have the burden of proving is that this occurred in this jurisdiction, which is Elk County, Kansas. That's a question of fact for the trier of fact.
But isn't it jurisdiction could be challenged at any time?
All right. I'm going to find that you're waiving your right to an attorney. I have requested you to answer that question numerous times. I'm going to set this. Stop interrupting. I'm going to set this matter for trial.
Before you do that, I still have I haven't answered my question. I'm trying to understand to come to a conclusion to see how I'm going to handle my case.
All right.
I'm still not
you have been asking questions that are not relevant to these proceedings, and I think you're aware of that. I've seen these motions before. I've seen the people try to do exactly what you're trying to do now, where you're not going to piecemeal this out. I've answered your questions, and I'm setting this matter for trial. That would be in person at the Elk County Courthouse. Sarah, we need to have a 2-hour, stop talking. We need to have a 2-hour setting.
Can you correctly reflect that this court plans to bring a case against me, which it will not let me know what I'm going to be facing against? Because I'm just asking a question to get a proper understanding what's going against me. Because I'm not understanding the jurisdiction of this, which jurisdiction I'm going to be tried under. That's all I'm asking, just to get some type of clarification. That's it. I'm not playing any games. This is a serious matter. This is a court date. I came all this way to understand, to see how it's going, to properly defend myself. I'm not trying to waste your time.
Not going to argue with you about.
No, I'm not here to argue either, Arne. I'm listening to what you're saying. I don't want to. I heard everything. It just I want to understand what's going on, and if it's how does the trial work if I don't?
You need to be quiet now, Sarah.
I have one question.
Sarah, no, Mr. Kervin, I've told you need to be quiet now. Sarah, do you have a date for trial, please?
I have a question. If I don't want to do a trial, what's the other option?
Okay, Mr. Kervin, I'm waiting for the clerk to give us a court date, please.
Yeah, that's
nothing further.
I'm asking. You need to, because
Mr. Kervin, if I have to tell you one more time, you need to be quiet. I'm going to find you in contempt.
Yes, Judge. We can do the morning of October 28th at 10 a.m.
October 28th at 10?
Yes, sir.
Okay, our trial will be October the 28th at 10 a.m. That will be at the Elk County Elk County Courthouse. Mr. Kervin, as I've explained to you, you have the right to be represented by an attorney. That is, if you wish to ask them questions, obviously that's appropriate to do. If you're going to represent yourself, we're going to be going with what the rules are here in Kansas, not something that you've read online or in line with what you filed. So if I strongly represent or indicate that people are better off being represented by counsel, but that's your choice. But you understand what the potential penalties are. And if you're representing yourself, you're going to be held to the same standard as an attorney in regards to being responsive and how you conduct yourself and how you present your case.
Well, I was asking about my fines. If I wanted to not do the trial thing, how was a fine, or does it have to be set for a trial in order? That's what I'm asking.
All right. If you're wanting to plead guilty, you can. If you want to plead no contest, where you're not pleading guilty, where you're not admitting to it, but you're also not challenging what the state has done, you have the right to do that as well.
Yeah, that's why I wasn't challenged. I was just trying to understand. So how much is the fees or whatever when once that's settled, would that take care of everything? And I'll need to know like the amounts for whatever it is.
Well, I have told you what the maximum penalties are.
You-
I don't negotiate with people. I don't tell them what the sentence is in advance. I'm required to tell people what the maximum penalties are.
Okay, so you said the penalty was jail time, but you didn't say the cost.
I said that the court, excuse me, I said that on a Class B misdemeanor, which this is, the punishment is up to 6 months in the county jail and a fine not to exceed $1,000. Court costs on this type of case are $108. There can be other things that are assessed as well. If a person was taken into custody, generally there's a processing fee of $45. Additionally, if somebody is found guilty, if they're placed on probation, there's a fee that goes along with that. There's various things that occur with that. But as far as the penalty section, I've advised you what the maximum penalties are.
Okay, so for the fees will be like you said like 1,000 and then about 40, so like about almost
I said that the maximum penalty is 6 months in the county jail and a fine not to exceed $1,000.
Okay, so do you have a number for me so I can see if I'm able to pay to see how much I would if I can even.
Okay, Mr. Kervin, what you're doing is asking me to give the sentence before you pled guilty. We don't do that. I've explained that.
If I do the no contents is what so I'm not arguing with you, you know. I'm just if you said no contents is not an argument. So if I do no contents, what am I looking towards?
No contest. It's the same penalty. A no contest, you're not challenging what happened. What happens then is we ask for the state to proffer what their evidence would be. That means they make a statement to the court. If the factual basis that they recite, if that was their evidence at trial, then a person is found guilty. It's not a situation where you get to contest that. If you're wanting to contest what the charge is, that's what a trial is.
Okay, yeah, that's why if I want to do the no contents, I want to see what the state would have to say. That's what I'm trying to see if we can take care of this and resolve this, because I'm not arguing with the courts.
All right. Have you been in contact with the county attorney's office prior to the court proceeding?
No, just today, just right now. I believe I sent a copy of my documents, but I haven't spoke to them anything about anything else.
All right. The court is not a part of any negotiations that can occur between the person charged and the county attorney's office. Ms. Gillette, are you willing to speak with him if I call a brief recess?
Sure.
I didn't hear your response, Ms. Gillette.
Sure. Yes. Sure.
Okay. Mr. Kervin, if you want to speak with the county attorney about what her recommendations would be, I'm going to do what they call a breakout. And so we'll be putting this case on pause. On the screen, it'll ask for the person to click it for the breakout room. Then that's basically a private conversation with whoever's there in the room with you and then the county attorney. It's not being broadcast out. It's not something that I hear. So I'll grant a brief continuance. We'll be in recess for that. And if the clerk would do the breakout room, please.
Okay.
All right. Record will reflect that both the record will reflect that both the defendant and the state have returned from the breakout room. So we have the same appearances as before. Mr. Kervin, did you get an opportunity to speak with Ms. Gillette?
Yes, we spoke, and I believe we came up to an agreement.
All right. Ms. Gillette, is that correct?
Yes, Your Honor.
And what's the agreement as you understand it?
He's gonna plead no contest to driving without a driver's license. And my recommendations are going to be $100 fine, court costs, no jail sentence, pay in 60 days. And that if he doesn't pay, his license would be suspended. He does have a cash bond that he paid cash. He would consent to any fines and costs being taken from his cash bond. There's a form he'll need to sign at the county district court office over here. And then any difference would be refunded to him. So he does have the money here and it will be paid out of the cash bond he has on file. I did look up, I believe it is a cash bond. And the difference would be refunded to him. Those are going to be my recommendations.
Okay, so you're recommending a $100 fine and court costs, is that correct?
Correct, Your Honor.
All right. Mr. Kervin, is that your understanding of the agreement?
Yes, sir.
Okay, Mr. Kervin, you need to understand, like I mentioned before, the court is not part of the plea negotiation process. So I'm not bound to follow the recommendations that the parties make, even when they've agreed to it. The court could sentence you to the maximum that I told you. I'm not saying that's what I'm going to do, but you need to understand that legally is possible.
Yes, sir.
Okay. With that in mind, is that correct? You still wish to proceed with a no contest plea?
Correct.
All right. Do you understand that with a no contest plea, you'd be waiving your right to a trial?
Correct.
And has anybody forced or coerced you in some fashion to make this decision?
No, sir.
Very well. Ms. Gillette, what would the state's evidence be if this matter were tried?
Yeah, the defendant was driving home from Greenwood County. He had a case up there. And as he was driving home, he was stopped here in Elk County. They did not know that he had been in court up at Greenwood. He was stopped by Deputy Mike Nelson on February 6, 24 at 3:30 p.m. on Highway 160 and 99 Junction. He was driving a 2007 BMW with a Texas plate. He had no driver's license. I don't know if he just hasn't renewed it and it's expired. Oh yeah, I do. It was expired. And he has not renewed his license. So his license is considered expired. So he had no DL. We charged him under 8-235.
All right. I do find that there has been a factual basis that support the charge. And I do find the defendant guilty on his no contest plea. We'll proceed at this time to sentencing. Does the state have any additional statements that you wish to make?
No, Judge, just the fine, court cost, and apply his bond and refund the difference.
All right. Mr. Kervin, are there any statements you'd like to make before I pronounce sentence?
No, sir.
Okay, Mr. Kervin, do you have your driver's license now?
It's just an occupational license that I used to go back and forth from work, but not an actual license. It's just like kind of like a work permit type of thing. And I'm not driving. I came here with my family member to bring me here to come to this court.
Okay. I'm not familiar with, is it Coolidge, Texas that you live?
Yeah, I'm in San Antonio now, but that's where I was staying at before.
Okay. All right. Texas requires a driver's license. And Kansas and Texas are a lot like each other in the sense that most people to get to and from work and so forth need to be able to drive. I strongly encourage you to get a proper driver's license. I'm going to pronounce sentence now. I'm going to impose a $100 fine, and I'm going to assess court costs in the amount of $108, which is the statutory amount. I've considered giving you a jail sentence. I'm declining to do so. So there's not a jail sentence imposed. However, I am going to require that this be paid. And you have cash bond that's here in Elk County, or did you post that down in San Antonio?
It was Republic. It's in Kansas. Where I got picked up. I think it's Republic County or something. I bailed out
Okay.
there.
Let me check with the clerk in a minute and see if they've got that transferred up here now. Sarah, can you answer, is there a cash bond on hand for Mr. Curvin?
Yes, sir. We do have a cash bond posted for him.
And is it in excess of $208?
Yes, sir. It was 2,500.
All right. Okay, so Mr. Curvin, following this here, I'm going to order that you pay that today. You have the cash bond on hand. You can come over to the clerk of the district court. They've got some paperwork for you to do in regards to that. So you'll be paying the $208. They'll be refunding the other funds to you, and that will complete this case. Again, I strongly encourage you to get a driver's license. You're a young man still. I'm sure you're going to need one for work and various things. And the vehicle apparently was properly tagged. This isn't a case where a lot of times some of these things we don't have a tag and there's no insurance, and you're not charged with those. So I'm assuming you had those things. But you can really get yourself in a bind if you keep accumulating these type of charges. And most states will generate a license for you and then suspend it, and in Kansas, I can't speak for Texas, but in Kansas, there's some mandatory jail time on driving while suspended. So, for your benefit, I'd strongly encourage you to get a valid driver's license. This matter is adjourned and the parties are free to go. Thank you.
Well, guys, we have come to the end of this proceeding. Listen, I'm going to be honest with you. I didn't see this thing playing out the way it did. But as we can see, he tried it for a little while. This time, instead of going into the common law and admiralty law, now he starts talking about civil law. But, it's right back to this is criminal law. And we see that Judge Lee was like, listen, this is not going to prolong. We're not going to drag this out. Be quiet. I'm not having it. Shut him down a couple times. And what I realized is once Mr. Curvin realized that, Judge Lee wasn't having it and he wasn't playing, this was going to trial one way or another, he was like, listen, let's make a deal. Let's talk a deal. So he knew the jig was up. He knew that he was playing games. He knew exactly what he was doing, because once he saw that he wasn't going to be able to prolong this thing, then all of a sudden he starts talking deal. And as we can see, the prosecutor recommended what she recommended after they went into the breakout room together, and the judge pretty much went along with the prosecutor's recommendations, but he strongly advised Mr. Curvin to get that license. And I thought that the judge was very sincere in his talk with Mr. Curvin. So, I appreciate that, because I know it had to be aggravating dealing with this guy with all of the nonsense, the rhetoric, the back and forth. But yet, the judge didn't allow it to become personal to where he gave him jail time because of that, because he said he thought about giving him jail time just because of the charges and what the case could possibly, the jail time that could possibly be sentenced on the case. But we noticed that it didn't seem like Judge Lee took this thing personal, and it's probably because he's been dealing with these type of individuals for so long and dealing with this type of stuff. So with that being said, as you guys can see, I'm in the car once again at work, but I wanted to definitely get this done. Got the little ear pods in and everything. But yeah, I appreciate you guys, man, always for joining me. We're going to keep these videos going. Once again, this is Sovereign Citizens Hall of Fame. I appreciate you guys joining me. And with that being said, guys, court is adjourned. See you guys soon.
All right. The city of Detroit versus Bernard Brandon Little. Case numbers SP 1513015, counts 1, 2, and 3. SP 1513029-1. SP 1556287. Counts 1 and counts 2. SP 1556352, counts 1 and counts 2, and SP 6353, counts 1 and counts 2. Appearance for the record, please.
Good morning, Your Honor. Alexis Schneider for the people, P80332. I have one of the issuing officers present.
Okay, and good morning, officer. Can you state your name for the record and your badge and cover, please?
Yes, sir. Officer Brown, badge number 1410, out of the 11th precinct.
Your Honor, could I get officer to repeat his name? I had the printer going at the part of the time.
Yes, Officer Paramo, badge number 1410, out of the 11th precinct.
Can you spell your last name?
Outside voice.
Oh, louder?
Yeah, because we're over here. That's
Okay. Okay, Officer Paramo, badge number 1410.
Spell the last name, please.
Paramo.
Thank you, sir.
Mr. Little, good morning to you. Can you state your name for the record, please?
Bernard, for the record.
Today is the date and time set for a trial on the matters. Let's deal with the officers that did not show. SP 155-6287, counts 1 and counts 2. SP 155-6352, counts 1 and counts 2. And SP 155-6353, counts 1 and counts 2. I'm gonna, on the court's own motion, I'm gonna dismiss those because the officer did not appear.
For the record, Your Honor, I'd like the record to reflect those matters are dismissed without prejudice, please.
For the record, Your Honor, Edward Taylor appearing with Mr. Little as advisor.
Very well. I'll dismiss the matters and they will be without prejudice. But the officer's gonna have to come with a very good excuse for why he didn't show up today. He didn't give any response. But now, nonetheless, those matters will be dismissed.
Listen, if you guys follow this channel, you know that when somebody deserves a shout out, I am going to give it to them. And Judge Perkins deserves a shout out when it comes to him being willing to hold this officer accountable for being a no-show. And why is that important? Because on this channel and in life, accountability is key, right? One of the main things I talk about is that these sovereign citizens, the major problem I feel that they have is just not being willing to be accountable for their actions. So that's why a lot of them show up with the stuff that they show up with most of the time, because they don't want to be held accountable for the things that they have done. So if they are expected to be held accountable, then obviously our law enforcement officers should be held accountable too when they drop the ball or miss the mark. So once again, shout out to Judge Perkins for that.
Okay. Now, we have the SP 1513015, 2 and 3, and the SP 13029 left. Mr. Little, the problem that we have here is that we don't have a jury.
Okay. We'll set it for another date for a jury.
We would have to, but I'm gonna say this. Mr. Okay. On the initial matters, SP 1513015, counts 1, 2, and 3 were all civil infractions. And you entered into an agreement to pay those civil infractions.
Yes, if you allow me to elaborate, John, my honor. Your prosecutor had an issue, and I decided, well, I wanted to figure out what she was going to do in return to me paying that, because I had already come up with an agreement with the courts. So that was like a contradiction to it, because I didn't agree to go back and forth.
Wait, you're confusing me now.
Well, I was confused too.
How are you confused? You set up the payment plan.
I had agreement with the court. I had a payment plan, right? I wound back up in court.
All right, to silence your device, please.
uh, with the courts to pay it. I got back in court, she didn't want to honor it.
Okay, Ms. Snyder, go ahead.
Your Honor, I believe Mr. Little might be describing just paying civil infractions without coming to court, which is something that citizens are able to do in this jurisdiction. He would have to come to court for the misdemeanor. I don't have an independent recollection of that, but that might be something I would do, not agree to dismiss the misdemeanor for a payment plan. I did share with him before he had his appointed counsel, his license comes back from suspension in 10 days.
I don't want to.
He doesn't want a license.
I don't ever want a license.
He doesn't feel that he needs to even have a license,
Thank you,
right?
Your Honor. Thank
I
you,
mean,
Your
come on, that's what the real is, right?
Thank you, Your Honor.
At some point, though, you wanted a license, didn't you?
Yeah, when I was 12, when I was
And at some
13.
point, you were Bernard Little.
No, we never have it.
Never been?
Never been.
So what did your mom name you when
My
you
mom
were?
named me Bernard. That's what she named me.
And where did the Little come from?
I don't know, my slave master, I guess.
Now, that might be true. Now, that might be true.
It maybe even come from my tribe.
It may be. You may have a point there. But at some point, your mom, what do you have to say about that, Mr. Taylor?
It's above me,
It's above- So,
Thank you, sir.
what it is this. He's entered into an agreement to pay civil infractions, 3 of them. I see it here. I think he made a payment for.
I did, yeah. I know I stopped paying once I came to court.
All right,
And
so
was denied access to pay.
what do we want to just dismiss the misdemeanor? He's paying a related civil infractions?
I have no objection to that, Your Honor.
I think all right. All right, I'm gonna dismiss SP 151-30291. I am gonna note the contradiction in your actions, though.
What's that, sir?
By you paying this, you're admitting that you should have expired plates, that you should
what I'm
have
doing
plates
is-
and no insurance, or are you just saying, hey, I'm not even gonna deal with it, the state
What
and
I'm
the
doing-
city is so off base with what they're doing,
Yes.
I don't have time to.
Thank you, Your Honor, for saying
Okay,
it. Yes,
I
sir.
got that, I understand.
Thank you.
Case dismissed, and we don't have a problem anymore. I'm gonna waive any warrant, I don't see any warrant fees. That'll be that'll close the matter up.
Everything's closed, Your Honor.
Everything except for he needs to continue on with the payment plan.
Very well.
And those matters will either, he'll either pay them or they'll go into default again, and they'll come after him civilly for the money. Okay.
Thank you, Your Honor.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
Thank you.
Hey, take care, everybody.
Guys, we are at the end of our video, man. Listen, I'm gonna tell you, I like when stuff like that happens. Like I really enjoyed just now the back and forth between Judge Perkins and Mr. Little, you know, in a good way, right? You could tell Judge Perkins took a little liking to him. He's having a good time. You know, he brought up him not really wanting a license. You know, don't worry about it. He don't care about that license. Him bringing up his mother, naming him Bernard Little. Remembering the things that Bernard said in the second video. And if you didn't see it, he called his own mother agent of the state for naming him Bernard Little. But, you know, the judge, he's just remembering all those things. He's having a good time. I think he really took a little liking to Bernard, because if you notice, he started advocating for him a little bit and kind of fighting for him. Because if you listen to Mr. Bernard, he kept saying, "Oh, thank you, Your Honor. Thank you, Your Honor." You know, so it was just good to see both of them having a good time. Obviously, the officer that didn't show up dropped the ball, so those charges was dropped. The rest of Mr. Little charges was dropped, besides him having to pay those civil infractions. So hopefully, well, I was going to say, hopefully Mr. Little stay out of the courtroom, but if he's going to be driving around without a license and things of that nature, it's probably going to be hard to do so unless he's lucky enough to just stay out of the law's way or not run into the law. But once again, man, it's always an honor and a privilege to share these videos with you guys and share a little bit of commentary with you guys. If you like the video, if you like the channel, please subscribe to the channel. Please like the video, share it. It will help us with the YouTube algorithm, especially being a new channel. I would truly appreciate that. And listen, until the next time we find ourselves in another courtroom, know that I appreciate you guys. God bless, and I will see you then. Peace.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.